Thanks for staying with us on TVC Breakfast. And still on the judgment of the Presidential Election Petition Court, the candidate of the People's Democratic Party, Atiku Abubakar, says he is prepared to approach the Supreme Court to set aside the election of President Bola Tinubu.
It is a judgment that I refuse to accept. I refuse to accept the judgment because I believe that it is bereft of substantial justice. Consequently, I have asked my lawyers to activate my constitutionally guaranteed rights of appeal to the higher court.
The Labour Party presidential candidate in the 2023 election, Peter Obi, has also rejected the judgment of the Presidential Election Petition Court. Mr. Obi describes the judgment as conterminous with justice, insisting he will exhaust all legal processes available to him. Speaking with journalists at Onitsha, Anambra State, Mr. Obi disagreed with the judgment but praised the panel for delivering the judgment within the stipulated time frame. He revealed that his legal team has already received firm instructions from him to file an appeal against Wednesday's decision while expressing unwavering determination in his pursuit of justice. And as we enter into the next half of the program, TVC Breakfast, that's what we will be carrying on with. It's the biggest story in Nigeria at the moment. And joining us on this leg of discussions in the studio is lawyer Fred Nzeakor. We'll also be bringing in due course via Zoom another lawyer, Liborous Oshoma. It's good to see you again.
Thank you.
Fred Nzeakor, welcome.
Thank you. Good morning.
Let's begin with updates or reactions from the lead opposition parties who were, of course, the petitioners, the PDP and the Labour Party, and falling out from that judgment, they have said they will appeal. And, a key grouse for them now is the role of INEC. INEC had said, or is quoted to have said before the elections, that they were ready to conduct the elections electronically. But with the court now saying, the tribunal now saying that they were at liberty to determine the powers or the extent with which they would transmit the elections. The parties concerned, the Labour Party, for example, and some lawyers have even said, is the appeal courts endorsing the actions of INEC and what that could mean for the polity in future elections?
Let's lay a very brief foundation so we'll be able to understand the issue.
Absolutely.
Two major statutes, laws, guide electoral process in Nigeria. Number one is the Constitution of Nigeria, of course, which created INEC and then other agencies of government. Number two is the Electoral Act. In this case, the Electoral Act of 2022 was the act that controlled and regulated the 2023 general election. The third thing that affects the election is INEC guidelines. That is where the crux of the matter lies. INEC guidelines. Before the election, INEC issued guidelines and even promised Nigerians in very extensive form that election results were going to be transmitted real-time online and that Nigerians will have the opportunity for the first time to view the results on their portal, the INEC result viewing portal. And it raised a lot of hope about the integrity of the election and the nature of the results that we're going to come there from. So, Constitution on one side, it is rock solid. Electoral Act on the other side, it is rock solid. What of INEC guidelines? Does INEC guideline amount to law? That is one major issue that we must solve in this country. So that we will now know when INEC begin to make their promises, you will now know whether the promises are to be taken seriously, as you must take seriously the contents of the Electoral Act and the provisions of the Constitution, or you are going to take those promises and those guidelines with a pinch of salt. This thing happened in 2019 when INEC said results were going to be collected through their portal. And INEC came out and said the portal was non-existent. And the matter dragged up to Supreme Court. Now it has happened again. Nigerians are relying on INEC guidelines and INEC promises. So the Supreme Court, the Court of Appeal, sitting in petition tribunal, said INEC was not mandatorily or compulsorily obliged or obligated to transmit results electronically.
So this
simply because it is neither captured in the Constitution nor in the Electoral Act. And there were contentious issues between INEC on one side that have made promises and the Nigerian populace and the electorates on the other side who have been, in quote, feeling hoodwinked by INEC and who had been given the short end of the knife and to whom promises made by INEC had been broken. Now, in the face of this contention, INEC was trying to give excuses that, look, we had glitches. Whatever the glitches mean and whatever caused it is left to INEC to explain. INEC, I've been asking this question. Assuming INEC naturally and truly had glitches, would you blame them? Assuming, without considering that there was glitch, would you blame INEC? And that was why they now said they had a backup in the plan B, which was the electoral, the manual collation process. We must begin to interrogate this process and say, will INEC guideline form part of the electoral law? If not, then we now know that what INEC is saying may be different from what Electoral Act is saying. Because the Constitution and the Act have given INEC the authority to conduct the election, the second schedule of the Constitution, authority to conduct the election the way and manner they deem fit, provided they observe the provisions of the law. And what are the law? The Constitution and the Act.
And we saw those two legal documents. Now, we saw them robustly used by the panel of justices. I don't think I heard any mention of the electoral guidelines. But legally speaking, yes, what is the legal value of, guidelines? Are they supposed to be like an addendum to a law? And are you saying they are not binding at all? Or is just to guide the agency in question and not exactly binding?
They cannot be binding, because they are guidelines. They are not even quasi-laws. They are not. They are, for what they are, guidelines, essentially to guide INEC and their staff in the conduct of the election, judging and drawing the source of inspiration from the laws that are binding, which is the Constitution and the Electoral Act. And now, if INEC has said, we are going to transmit the result electronically, and somewhere along the line, they failed to transmit results electronically, the court felt that INEC had not breached any law. If we want the result to be transmitted electronically, we should amend our Electoral Act and include it. The same way we have included the use of beavers, that piece of technology which was replaced the card reader, and specifically mentioned it. So we will now have to begin to look at issue of morality. If you promise me and you fail, it lies in morality. But if the law says you must do this, it lies in law. Now, issue of electoral morality and electoral law must be clearly distinguished and firmed up. If we want to, aspect of that morality that we know that will very strongly affect the law, let us concretize such morality and make it law. So that INEC will operate within a straight jacket and will not have so much room to operate like the foot of the chancellor.
Talking about the transmission of election results to IREV, and because of the glitches that they experienced, in the guidelines that we talk about, the INEC guideline I'm trying to look for, I think it's 45 or thereabouts, saying that the election will be collated manually, even though it will be transmitted to IREV, paraphrasing now. So if they had said that, the determination of the election would be done manually, should not have even caused any problem in it.
Naturally, collation must be collated manually. What do you mean by collation? Look, the most important piece of document in an election is Form EC8A, the primary result sheet. It is that result sheet that emanates from the polling units. It is the primary result sheet that you now collate at the ward level to give you the ward result, collect at the local government level, at the state level, and ultimately at the national level. It is that same result that generated from the over 176,000 polling units in the country that coagulated at the national level, collated to become the national result.
Which every political party must have.
Which, by the provisions and by guidelines of INEC, every political party that participated in that election should have a copy. Should have a copy. Given to that party by the, to the agent of the party at the end of the result, of the voting. So, when you say manual collation, at that point, it was manually collated. You can only talk about electronic collation if there is electronic voting, as is done in the United States. You go to a computer, you press, you vote. We do that in the Bar Association. We have introduced that in the NBA, and then you just sit, even in your comfort of your home, in your phone, and you vote. That is electronic voting and electronic collation. As you are voting, the computer will be collating it. But when you manually thumbprint, it is manually collated. Results are counted and then entered in the Form EC8A. And it is that Form EC8A that INEC said will be snapped and forwarded, transmitted to the IRF portal.
Which is just like
So, if somewhere along the line, it was a battle. You recall when this issue was arising at the floor of the National Assembly, when during the making of the 2022 Electoral Act, that if along the line something happened and it couldn't get to where it was sent, you fall back to that Form EC8A, and you will naturally must continue collation at the ward level, at the local government, state and national level, manually.
Right.
And that's exactly what INEC did in presidential election.
All right, gentlemen, regarding the judgments delivered on Wednesday, let's bring in now another lawyer who joins us virtually. Liborous Oshoma, it's good to have you join us. Thank you. I can see you on the move. Thanks for your time with us on TVC Breakfast. But one crucial point now that have more or less generated diverse reactions within the legal profession and even the participating parties at the presidential election petition has been the issue of the burden of proof. Some are saying, should it be on the petitioners or should it be on INEC to defend its conduct of the elections, seeing as the 21-day mandates given to petitioners to file in their papers cannot be possible for them to generate the needed evidence for a petition of this magnitude?
Yeah, thank you. First and foremost, I want to apologize. I was supposed to be in the studio this morning, but hustling and duty calls, so I had to fly into Abuja first thing this morning. And
it's
so
fine.
My apologies for not being able to come.
It is fine.
Live.
It is fine. We understand.
First, also, like Fred had said, the guidelines to the Constitution and the Electoral Act, Section 60 of the Electoral Act, gives INEC wide power. INEC has so much power. And until you unbundle these powers, INEC will continually, consistently, have these powers. And to prove election irregularity will be a difficult one. Another one is the issue you just raised, a presumption of regularity. And let me break it down for the ordinary man to understand. The moment results are declared by INEC, or in the eye of the law, no matter the irregularity, in the eye of the law, the result is okay. In the eye of the law, the result is okay. It is you that is saying it is not okay, that will now need to prove why it is not okay. And it is not enough for you just to say it is not okay. You will now need to use witnesses that were present at the polling unit and results that were issued at the polling unit, one after the other, to prove that the results as declared by INEC, it's regular or it is not okay. What do you call it? The qualification of the candidate. But these ones are low-hanging fruit. The main thing in election is about numbers. And once you are not able to challenge the numbers, the law already presumes that that election is valid and it is okay. Once that remains, it will be difficult for anybody to upturn an election conducted and presumed to be validly okay. Once that remains, and considering also, like you have also said, not just the 21 days within which to file, Also, the 180 days to prove this irregularity. How do you prove 180 days within the entire federation? How do you prove irregularity within the entire federation and within 180 days? When the law also require you to prove polling unit by polling unit. Also, our attitude to election. Our attitude to election, this presumption is the intendment of that presumption was that the intendment of the drafters for including, by provisions of the Evidence Act, the presumption of regularity is that you will have men and women in INEC who will be above board. But when you have people conducting election who are partisan, who are questionable, then it becomes very difficult for you to now say, okay, that presumption should still stand. But if you now remove that presumption, what that also will mean, that's why I said our attitude to election, what that also will mean will be every time INEC is conducting election, they consistently will be looking above their shoulder because they will be called in court everywhere to come and show how the election was conducted and why it is irregular. So you might end up having a situation where you'll be conducting 5 elections within a stretch of 1 year for a particular office because consistently they are saying, no, you didn't follow this guideline, you didn't follow this procedure. So that brings me to the area where Fred talks about what we should do. You remember after the 1999 election, before the 2023 election, we amended the Electoral Act 2022. Before the 2007 election, we amended the Electoral Act 2006. Before the 2011, we amended 2010. So it's a consistent dynamic process that we need to update. So what we need to do now that we have said IREV, by the rules, IREV is not a...
But quickly now,
I'm sure INEC will be happy that there's a glitch here. They'll say that's the part of the glitch that they had.
We've all faced.
It's imported technology.
Network glitches.
You can always have glitches.
But the issue of the burden of proof, if you look at how far we have gone, election petitions, no petitioner has yet won a presidential election petition if you trail back to history. And now there's an issue of INEC has all the documents. INEC defended, in fact, Ebolu Adegborowa SAN said INEC defended as a respondent as if it was an interested party. But I felt INEC was an interested party because it was even the first respondent in the petition. So he is now saying that the burden of proof, lawyers are saying the burden of proof perhaps should be on INEC and not on the petitioners.
You don't change the goalpost at the middle of the game. The burden of proof in our jurisprudence, in our judicial jurisprudence, is that he who alleges must prove. It is even a universal jurisprudential dictum. He who alleges must prove. You don't just come and allege and shift the burden of proof to me. You know what you saw in that allegation. So you must come and prove it. And that is where my brother Liborous is saying the presumption of regularity must always take place. It is presumed that INEC, that had the authority to conduct the election, had conducted the election the way and manner it was supposed to be done and had delivered the result. So if you now pick holes without result, you are now alleging that there were manifest irregularities. You are now the alleger, in quote. So you have to come and prove your allegation. So you can never shift the burden of proof to INEC because you are the one who alleges. And if you are now talking about what did INEC do well and what INEC didn't do well, it is a continuous process. People learn and adjust their laws based on their experiences. Now we have seen from this last experience and the judgment of the court that if you want to give INEC so much latitude, you must also give INEC so much confidence and trust. If you don't want to give it so much latitude, bring INEC within the precincts of the law, stricto sensu, in the Electoral Act, so that INEC will be limited in their utilization of discretion If they now use their own discretion and you begin to pick holes with the discretion, why did you now allow them that discretionary authority in the first instance? These are some of the things that we must critically look at, because there's no need crying over spilled milk. Once the horse has bolted, you closing the staple makes no sense. Let us ensure that that horse doesn't bolt. Some of those things that are now agitating the minds of Nigerians today are things that we should sit together in town halls, in different fora, and discuss and sip out and implant them in our laws, because it's a dynamic process, so that by the next round of general election, there will be improvement. Oh, Nigerians now like IRF. No problem. Make it a law. The same way beavers have been made a law. When beavers was introduced, then as a card reader in 2015 election, before then, there was a lot of agitation against it. But after the utilization in 2015, it was found out to be a very good deployment of technology. The
key petitioners, that's the PDP and the Labour Party candidates, have said they will press on in their desire to reclaim that mandate, so to speak, and that they are going to appeal that judgment, saying they want justice. And that's what we have been dissecting. Ibrahim.
Absolutely. So let me take it up from where our studio guest ended. You talked about making IREV, including IREV, just the way we incorporated beavers into the Electoral Act. And IREV should also be recognized that way. But I want to understand, make us understand how you think this can be well incorporated, because of the fact that we can't guarantee glitch or attacks on a cyberspace. Look at the Electoral Act 48 says, an election result shall only be collated if the collation officer ascertains that the number of accredited voters agrees with the number recorded in the beavers and votes scored by political parties on the result sheet is correct, and agrees with the results electronically transmitted or transferred directly from the polling unit. So if you go to C, it's saying that if no result has been directly transmitted electronically for a polling unit or any level of collation, the provision of the clause 93 of this regulation shall be applied. And the 93 says that, okay, fine, assuming all of these copies have been mutilated, then we can always get a copy from the police officers and some other witnesses that are there. So, but in the peradventure, IREV doesn't work the way it didn't work, to some extent during the presidential election. Then wouldn't that be a stall to making progress in the electioneering process?
In every law, there must be room for a plan B, which you can call an exception. Even with the beavers can even fail. You recall that the card reader failed in some instances, and then we resorted to use of manual entry, right? Manual verification, which we call the incident form. And until it became so experimented and then almost near perfect before now the beavers was now incorporated into the law. So if you make IREF part and parcel of it, you also make a provision. The next leg will be a proviso that in case it fails, then we now resort to manual collation. Because what can never fail is from EC8A. And since the hood does not make the monk, the IREV does not make the result. What makes the result is from EC8A. The only thing is that with the electronic collation, it is faster, it is more reliable, because it removes the incidences of the hand of the monkey in the pot of soup. But where it fails, what do? You resort to manual collation. Where it fails. So if we want to make that provision, we make that provision. And that could be guided, well guided. And if eventually, if it fails, it will now resort to manual collation. And at the end of the day, that from EC8A will still give you the necessary result. Part of the things that when we talk about revolutionizing our electoral process, some people keep kicking and keep insulting the justices unnecessarily for what they didn't cause, instead of them to look at where the problem lied. The problem lied with INEC that gave promises and failed. You promise a woman, I want to marry you, and you fail. Who are you going to be? Who is the woman going to be angry with?
I still want
so INEC made promises and failed. But the justices had challenges. INEC was giving an explanation. It was difficult for them to lie on the side of the people and ignore the explanation of INEC. It was so difficult to lie on the side of INEC and ignore the agitation of the people. So what would expect the court to do? The court will now operate strictly on what the law has provided. And that was why they ran only with Constitution and the Electoral Act. In amending our Electoral Act, let us also look at this possibility of exhausting all legal battle before inauguration. Exhausting all legal battle, especially for elections into executive offices of the president and the governor. Let us exhaust all legal battles before inauguration. These are part of the things that we need to put in our laws.
We must spend some time to explore, reforms to the electoral system ahead, before we sign out on the program today. But in the meantime, Mr. Nzeakor, let's quickly check with Mr. Oshoma now in Abuja. Let's talk some more and hope that, network would serve us better this time around. So there were reports from ECOWAS, and there was another report from the European Union on the conduct of the elections months before the Court of Appeal handed down that judgment on Wednesday. And these two documents served as among the several evidence proffered by the petitioners, which, however, failed the court ruling that these reports had no value. What are your thoughts on this?
Yeah, see, we are all lawyers. I can't sit down in Abuja, generate a report about my experience in Lagos, and then give it to Fred and say, Fred, go and tender it for me. Because of the law of auditory pattern, hearing the other side, giving the other side the opportunity to interrogate me, my rationality, and how I arrive at that report, the court will not reckon with that report when it comes to election matter. Because for election, justice must be seen to be done to one party. Justice is not only done to the petitioner. Justice must be seen to be done to the respondent. Justice must be seen to be done to INEC also. Let me start by first and foremost saying that INEC, the moment INEC declares a result and the result is presumed by law to be irregular, INEC becomes an interested party. It's no longer an umpire. Because INEC now, the responsibility is now on INEC to defend that which he has done and that the law presumes regular. You need to understand it from that perspective. So that's why in most cases people say, no, INEC should be an umpire. INEC is not an arbiter. INEC is not a judge. The judge is the umpire in that matter. That's on one side. When you generate a report, what the petitioner ought to have done would have been to call a member of these observers that generated the report so that the other party can have opportunity of cross-examining them on how that report was arrived at. Where, how they arrived at the report, the places you said you visited, somebody can cross-examine you on it. But that is the way law works. I might not agree with it, but that is the law. That is the way it works. So if you say, oh, this was a report generated by somebody who is now in Kenya, and the law says, bring the person so that this other party can have opportunity to ask him questions. You say it's no more here. The law will say, well, I cannot rely on this report because relying on it will give undue advantage to you against the other person. That's on one side. That's what happened to the EU report and the ECOWAS report. Also, in simple tests for proving irregularity, a political party says we had polling units in all the 170-something thousand polling units. How come they could not even call one person? And then we keep quiet and blame the judges instead of blaming the lawyers who handled the matter, who could not, you dwelt on the minor, the low-hanging fruit. What of in the event that the low-hanging fruit fails? What should happen to your petition? It will fail because you are not dwelling on the major. And friends talked about from EC8A. The way to disprove and attack an election petition is to ensure that you attack the Form EC8A. That, look, the Form EC8A that you have brought before the court is not authentic. The one you issued to me is different from the one that you are presenting here. Or that the one you gave to me is clear. The one that you are presenting here is mutilated. The one you gave to my agent at the polling unit, this is it. because the agent was there, he represented me. He's the eyewitness and not hearsay evidence. These are ways you shift the burden of proof. And also the question of burden of proof, presumption of regularity. Like I said before, the challenge here would be you will now have to also change constitution. Section 36.5 that presumes every man innocent until proven otherwise will not presume you guilty until it is time for you to prove your innocence. So this is the jurisprudence we are practicing. IREV, on the issue of IREV, the law says IREV is a regulation. The people that are rejoicing today, celebrating the Supreme Court, Court of Appeal judgment, mind you, they condemn the Supreme Court judgment in Oshoma. Excuse me. Those that are condemning it today celebrated it in Oshoma. Meanwhile, it was on the same IREV that it was the Supreme Court decision, not even the Court of Appeal. It was Supreme Court that said IREV is not a requirement of the law. That the requirement of the law is EC 8A. Even in London, in America, and the rest, they still have manual voting. You cannot completely, like Fred said, completely replace the manual process with electronic. But you can allow the two of them to coexist. Just the same way we have made accreditation electronically, we can also make transmission electronically part of the law. But I then put a caveat. In the event that it fails, you can now resort in areas where it will fail because we are still having challenges with technology. So once that becomes part of the law, it now behoves on INEC that they must, as of right, transmit results electronically, except it can be shown that it will fail. And then it will still bring us back to this issue. INEC can always tell you that there is a glitch. So what we need to do, we should have, our orientation about elections should change. It shouldn't be a do or die thing. Once we have an attitudinal change towards election, all of this attitude of, oh, I must kill everybody because I want to rule them, I must win at all costs, will no longer be there. Why is everybody now looking towards government? Because there are no opportunities, there are no jobs. But if government also provide jobs, provide opportunities for people, all of us, not everybody wants to be in government. Not everybody wants to be in power. So these are some of the challenges that we all need to deal with holistically in moving our election forward. Otherwise, every 4 years like this, we'll come, we'll banter, we'll bicker, we'll insult each other, we'll fight each other over election. And at the end of the day, you think that the court will nullify the election. They will not, because it becomes very difficult. Now, also quickly, lastly, because Fred also talks about dealing with pre-election matters before handing over. Must we go to court? The only way you can address all of this is not that, you deal with it before handing over. 180 days, we already say it is small. If you now abridge it again, if you conduct election a year before handing over, so you will need to, for you to deal with election matters before handing over, will mean that you will conduct election at least 1 year before handing over. So you conduct an election 1 year before handing over. For me, I've never seen a country that does that. So what we need to do is to ensure that we elevate our electoral processes, that they will not be challenged. This attitude of court having to determine our election at all times, we find a way to erase it.
Right, makes sense. Liborous, I'd like to stay with you for a bit. So based on the backgrounds and all of the perspectives you brought to it, do you think that presidential election petitions are judged not based on the integrity of their conduct, but on the presumption that the declared winner would still have, despite the irregularities, not have won? The only thing that the declared winner, the only thing that those who are contesting this result or these positions would have meant that they only registered their grievances, or to also say that the election that produced the victor is not free or wasn't free and fair. Do you see it that way? Because it has never happened that whoever won the presidential election had been, declared, the result would have been declared null and void.
Yeah, we need to understand that the presidential elections the court deals with election on the basis of the provisions of the law. It is not sentiment. if you say there were irregularities, the legal foundation for proving those irregularities, like I said, if you say that the result that was produced was not what emanated from the polling unit, you will need to confront that result with another result that you said emanated from the polling unit. That is the position of the law. So the election, the court deals with these issues using the law as laid down. So it is not the sentiment or, from what the people think, the INEC didn't do it well. If INEC didn't do it well, they said, bring your witness to say they didn't do it well. That's what the law says. If the law didn't state that, then the court wouldn't have been doing that. So the challenge of proving irregularity is the fact that the law has put a very high rise at the doorstep of the man who is alleging that the elections are not regular. I give you an example. If you say elections were not regular in 300 polling units, that the scores that you have were different, the score that you were allotted or that the score that were given to you is different from the score that you have, you will need to provide 300 witnesses. Who were those polling units? And you will also need to provide the result sheets that were issued to you at those polling units, different from the one that INEC is parading. So that's 300 witnesses to prove 300 polling units. So, and lawyers know that that is almost a practical impossibility considering the time that you have. So what do we need to do? When we look at all of this, how do you begin to prove all of those? So they look at the low-hanging fruit, issue of qualification, issue of documents and the rest. And that is why, like the Court of Appeal said, you said you were going to produce video evidence, documents, and the rest, and you didn't bring one. So if you don't bring any, it means the impression and the position of the law is that failure to bring them means that if you bring them, those documents are against you. It might also not be so. It might be that you couldn't even lay your hand on some of the documents. But the law already has set a trap for you and says, because you know if you bring them, that it will be against you, that is why you didn't bring them. And any court that says otherwise, the first thing the Supreme Court or an appellate court will do is to say that you did not follow the law. So our laws have been laid down on how to prove irregularity. Not the way the ordinary man on the street is seeing it, but the way the law has spelled it.
All right, Mr. Oshoma.
Change the law.
All right, Mr. Oshoma, let's manage the remaining minutes we have with us on the program this Friday. I want to get Mr. Nzeakor's views on the fact that, well, arguably or perhaps unarguably, that Nigeria is said to have the highest number of election petitions, going to court after elections to challenge the verdict, to challenge the outcome of elections. And people have said now that let us unbundle INEC, over insinuations of political interference and to make them more independent. Do you see that as a panacea, a solution now to, having less outings by politicians or election candidates in courts?
We cannot begin to solve the symptoms and leave the cause of our ailment. What had caused all this avalanche of court cases after every election? One, the do or die type of politics that we play in Nigeria because of the high pegs of office. Because of high pegs of office. You want to tell me, for example, that if we make the National Assembly a part-time job, that so many people will want to be interested anymore? You want to tell me that if we make it a unicameral legislature and make it even part-time? That is where you now see patriotic people, professionals, maybe bar association, accountants union, even students union, market women, all of them will now have representatives, and then things will begin to, what do there? They collect the opinions of the people and calculate them into laws. So that, and most of those laws are even done by the staff of National Assembly. They are even, the real work is even done by the staff of National Assembly. So these are some of the changes that if we have them in the system, and it will help us. If you say you want to unbundle INEC, where does INEC need to be unbundled? You unbundle them, you take away the capacity and the authority to conduct the election or to monitor political parties or to do what? I do not think that is the major problem. The major problem is the nature of politics that we play here. And the perception is very important. Look, when people feel that INEC has not done well, it affects their zeal to participate in politics. It affects their zeal to even go to vote. Some people have started even swearing that they will never vote again in their life in this country, and you see all that in social media. But that is because of an expression of emotional frustration, which they have had because of their the failure to achieve what they expected. And what is that failure? Because of that simple promise that INEC made and which INEC failed to execute. So if you now look at it strictly and you want to be on the side of balance, is it possible that INEC really had a problem? If it is so, why are we not giving them any benefit of the doubt? Why? So there's so many things that need to be done. And I can never stop saying it, that if we don't restructure the foundation of Nigeria, we will continue to be in this round robin.
What do you mean by this foundation?
Yeah, the foundation, our structure is bad. Very bad in the sense that this unitary system is not working. What we are practicing is pseudo-quasi-federalism, not federal structure. It's not working. And that is why every man will want to be in Abuja. How many people are interested in development at their zones?
Local states.
Until we do this. This is one of the major aspects of our policy change in a country, structural change, that will begin to solve some of these problems that we have. So that instead of us running to the apex, we now begin to have a base that is progressive. And then the apex will just be...
Okay, very quickly, because
will just be representative.
we have very little time to go. As the aggrieved parties are now moving to the Supreme Court.
Yes.
I'm not sure how much trust Nigerians have for the judiciary, especially reading what the outcry following the judgments and those who are not satisfied. We saw what the Supreme Court ruled in February between the former Senate, the former Senate and the former Senate
president.
President,
right.
Yes.
the
Yes, and
Lawan.
the Machina issue.
and the kind of language, the kind of tone that the judgment was read with, and all of that. So how do you think we can begin to have trust in the judiciary, and even at that, not even going to the court to finalize all election matters?
Education. Education is the key. Forget this half education that we see here and there, when people just pick their telephone and they type all manner of things that they feel they will assuage their sentiments without reasoning. It is very unfortunate that many Nigerians are depreciating in their reasoning power. Very, very unfortunate. And it now sends very wrong perception about the images of the judiciary and the justices of the courts. And everybody will now begin to blame them for what they did not do without knowing where the crux of the matter lied. Education. We need to intensify the education of our people.
All right. All right. That said, a final take from you, Liborous Oshoma, in about a minute, especially now that the next stage is the Supreme Court.
Yes, everything that the Court of Appeal said were already said by the Supreme Court before now. So what the Court of Appeal was just quoting were copious dictum and statement from previous Supreme Court, current Supreme Court, and then previous Court of Appeal. What was said that day before yesterday, nothing new was said. Everything that was said had been said before. So what we need, our politicians also need to learn to educate their people. Politicians are the beneficiaries of victory. Learn to educate your people. INEC also, to a very large extent, let us begin to have credibility in our processes. Once you do all of that, perception will always come, but let's learn to have an open mind to elections. It is not a do or die thing. And at the end, like I said, you cannot always win in court, because if you understand the nature of our laws and the way it works, you will not be expecting so much that, oh, the court will just come and work on sentiment. The court work on the basis of the evidence presented before.
All right.
And I ask a very simple question. If you have polling unit agents in all the 170,000 polling units, how come you couldn't call one?
All right.
Let us know what they were doing.
Right. A fine place to leave it there, Liborous. Thank you so much, Liborous Oshoma, for your contributions, braving the odds as well, despite the distance constraints. Liborous Oshoma, then Abuja, and of course here with us in the studio, Fred and Nzeakor, both of them lawyers. Many thanks for your contributions.
Many thanks.
Gentlemen. Thanks. We also thank all our other guests on the show today. Many thanks to you all, and we must of course tell all our viewers that the views and reactions of our resource persons are theirs and have no connection with us at TVC News. Thanks to you all for keeping us company by watching all week long. We hope you can join us again tomorrow for our new TVC breakfast show on Saturday. I'm Kemi Foladeyemo. Join Ibrahim Shita and I again next week for a full 5-day ride, right?
Absolutely.
Right.
Absolutely. It'll be a very jolly good ride.
All right. See you tomorrow.